Hello, everyone. This week we're going to be talking about prisoner rights. This corresponds with the performance objectives 4 and 5 of your syllabus. And really what we are going to be looking at is how the U.S. Supreme Court has interpreted the amendments and how they apply to both prisons as well as prisoners. And so in that, we're going to be looking specifically at the First Amendment, the Fourth Amendment, the Eighth Amendment, and the 14th Amendment. And again, one of the things to keep in mind, and I know we've talked about it in other classes as well, the U.S. Supreme Court has a great impact on how we do our jobs. And so a lot of people think of the Supreme Court as these 9 individuals off somewhere in Washington, D.C. And yes, they are. That's where they're located. But no matter what aspect of the criminal justice system you want to work in, those 9 individuals are your bosses. No, those 9 individuals are making the policies and the procedures that are going to impact how you do your job, no matter what aspect of criminal justice you want to work in. So the composition of the Supreme Court, as well as the types of cases that they're hearing each year, will impact you specifically in your job. Now, for many years, the courts did not interfere in the management of corrections. It was very much considered a hands-off doctrine in that they saw it as a separate entity, and the court said, you know what, you take care of your business, we'll take care of our business. That actually ended in 1970. Basically, it had come to the attention of the courts about a prison in Arkansas. And it went all the way to the Supreme Court. And basically, the Supreme Court agreed that the Eighth Amendment and the right against cruel and unusual punishment did apply to prison conditions. Now, this specific prison was in terrible condition. It was extremely old. Allegedly, there's in whether or not we don't have a whole lot of documentation from that time frame, but there was believed to be skeletons at one point in the early history. Offender or inmates were being beaten. The level of extortion and corruption among the officers was just amazing. The place was rat infested, including the food that the offenders were being fed. And so Holt versus Sarver basically said the Eighth Amendment protects against cruel and unusual punishment, and that applies to prison. So basically, this is a Supreme Court case that really got the ball rolling, and it really forced us to take a look at when an offender goes to jail, or most commonly prison is what we're dealing with, because jail is usually pretty short term, but it does impact this. When someone goes to jail or prison, what rights are they giving up? Now, a lot of this has evolved through civil rights litigations. Basically, someone has been sued in civil court for violating their rights. And for correctional officers, or as a future correctional officer, or as a future probation officer, you need to recognize that the court now allows you to be sued civilly, meaning in civil court, meaning you can't hide anymore behind your department. And for years, officers were able to hide behind, for lack of better terms, their department and get protection, where now you can be sued personally if you are found to violate someone's civil rights. A lot of this also begins with grievances that are filed, where an inmate will file a grievance, go through the policy and procedure of the facility, and if it's found that it needs further attention, it might go through the court system, and that's how a lot of these cases have made their way through, or all the way up to the U.S. Supreme Court, where a lot of times it starts with a grievance that an inmate files against a facility. So as I said, this really got started in 1970, and most of this was finished by 1991. So but basically what we're going to do is we're going to take a walk through some of these amendments. So taking a look at the First Amendment. Basically, again, the First Amendment is the freedom of speech as well as expression. And the Supreme Court decided that their job was to really do this balancing test, in that they were trying to balance or to weigh the rights of the inmates against what they refer to as peniological objectives. Basically, these are the safe and secure operations of the facility. So what the Supreme Court was really trying to balance is, what with these different amendments, whose rights are more important and why. And so they would always balance that with individual rights as guaranteed in the Constitution versus, again, what's called peniological objectives. So the First Amendment, your freedom of speech as well as your expression. In this particular instance, when we're talking about mail, the inmates lost this particular argument where they wanted their mail, their freedom of speech and expression, as well as privacy, should be extended to their mail, is what they argued to the U.S. Supreme Court. The Supreme Court disagreed and so sided with peniological objectives, saying the safety and security of what is written, what's coming in, as well as what's going out, is more important than the inmate's right to the freedom and privacy of their mail. So that is why we go through mail, both incoming mail as well as outgoing mail, with a fine-tooth comb. We're looking for contraband, we're looking for evidence of criminal activity, and we monitor their mail very, very closely, as well as their phone calls. The First Amendment, of course, also has the freedom of religion. And basically this one, inmates won for the most part. That is why we must respect if there is a religious practice regarding what food you can eat, when you can pray. For example, Native Americans in sweat lodges, most prisons are going to have one of those on their facility. And so basically your freedom to express your religion is guaranteed and extended to the prison environment. So for this particular one, the Supreme Court sided with the inmates. All right, so the Fourth Amendment, as far as search and seizure. Basically, inmates were arguing that their cell is private and your right against unreasonable search and seizure that you have in your home should be extended to your cell. This particular one, inmates lost. The Supreme Court said you have no expectation of privacy in your cell, and they extended that to also cover shakedown. A shakedown is when officers will go through a housing unit and basically go through the individual cells very, very thoroughly. They will pull apart, the between the mattresses and look through basically everything, looking for evidence of contraband or anything that might violate the rules of the facility. So basically the Supreme Court sided with the peniological objectives in the Fourth Amendment in saying that the Fourth Amendment does not apply. All right, taking a look at the Eighth Amendment. So the Eighth Amendment is what guarantees us against cruel and unusual punishment. Now, a huge piece of the Eighth Amendment is the death penalty. We're actually going to talk about that in a different week. What we're going to look at here is primarily medical care. Now, Estelle versus Gamble was decided in 1976, and what's interesting is this case was built based upon the Holt versus Sarver case that was decided in 1970 that I talked about just a couple slides ago. Basically, the Eighth Amendment, as decided in Estelle versus Gamble, says that the Supreme Court says we can't demonstrate deliberate indifference to serious medical needs or anything. We need to stop or not promote anything that causes, and this is a quote from their decision, pain, discomfort, or threat to good health. So that is why offenders are provided basic medical care while they're in a facility. Now, this medical care includes both physical health, mental health, as well as dental health, are all covered under the medical care. And again, it's the principle of least eligibility is what it's referred to, which refers to when you think of someone, the welfare, the medical care that is provided for those who are welfare dependent. the level of medical care is just below that classification or demographic as far as medical care. Now we're going to be talking about female inmates in the next couple weeks, but gynecological services. So although it was medical care was um, required by Estelle versus Gamble, they didn't incorporate gynecological services for women's health until 1994. So almost 20 years later before women were given the right to gynecological services. Now, the Eighth Amendment in cruel and unusual punishment also covers prison conditions. Now, we already talked about one, Salt versus Harvard, but ultimately, when determining whether or not prison conditions violate the Eighth Amendment, they're really looking at what's known as the totality of the conditions. So they're looking at the big picture. So, for example, just because a prison is very, very old doesn't necessarily mean it automatically violates the Eighth Amendment. They're going to look at the totality, but of the conditions. However, the 1970 Holt case, the prison was literally falling apart around the offenders, and so that is when it found prison conditions. When we started using solitary confinement as a sanction or a consequence for violating prison rules. It went all the way to the Supreme Court. There were the offenders were saying solitary confinement violated the Eighth Amendment. Supreme Court came back and said, no, it doesn't. Again, we're balancing inmates' rights and peniological objectives, but that they also said that offenders need to be allowed 1 hour out for recreation as well as personal hygiene. And so as long as those were being given, solitary confinement does not violate the Eighth Amendment. We have also now heard from the Supreme Court, so for some of our most dangerous offenders, that hour out that they get is basically inside of a cage. It has a shower, it has room that they can get up and walk around. Supreme Court has said that is acceptable as long as it's done in order to achieve peniological objectives. Inmates have also argued that overcrowding, this idea that we've gone extensively to double bunking, the Supreme Court basically said that double bunking does not violate the Eighth Amendment. It does not constitute cruel and unusual punishment. However, they did have a caveat to that and basically said there needs to be a minimum amount of square footage. Now, it's very, very small, but overall there needs to be access to overall square footage to make sure then that overcrowding is not violating the Eighth Amendment. All right, looking at then the 14th Amendment was really the last amendment that the Supreme Court has taken a look at. Now, of course, the 14th Amendment requires due process and equal protection under the law. And so basically what this just reiterated and what the Supreme Court reiterated is that any of the policies and procedures of jail or prison need to be applied fairly as well as equally. Now the ball really got rolling here in the Wolf versus McDonald case. And basically what this said is if an inmate is going to receive extensive disciplinary action, meaning more than lockdown for just a few hours or a couple days, that inmate deserves the right to due process, and so that is why they will have a hearing. Now, this is not a court hearing. They don't go over to a courthouse. This is held in-house. A lot of times, the program staff will also be the hearing officer, and basically they review the officer's report. They may call the officer to testify. They're going to hear the inmate story, and then they are going to determine what the disciplinary action is for this violation. Again, these are not used for minor infractions. We don't have full hearings for minor infractions, lockdowns for a few hours or a day or two. It's going to be extended periods of lockdown in solitary confinement or Equal protection and due process says that inmates have the right to access to legal materials. A lot of times we see offenders wanting to file multiple appeals and will want to do their own legal research. Now, the Bounds case, Bounds versus Smith, says in order to achieve due process, we must give inmates access to legal materials in order to be able to have access to the courts. Now, the vast majority of prisons do not allow inmates internet access. Most legal materials are now housed online. However, the West series, so it used to be of all of our case law and legal books, the vast majority of them were published by Westlaw. That has all gone online. When I'm looking for case law nowadays, I just go to my Westlaw account through the internet. They still do publish those books, hard copy books, primarily to cover this requirement for prisons. So in some people kind of chuckle and say that the prison is keeping the print industry of legal materials in business. Basically, in the late 80s, very early 90s was really kind of the end of the area of this legal reform for the most part. The Supreme Court, now this is just what I just reviewed was a brief overview of some of the primary cases. Now, the Supreme Court heard several cases in there, and by the end of the 80s, early 90s, for the most part, policies were pretty much put in place. They had pretty much covered the main issues. However, as I said, women's issues are still being argued. It wasn't until 1994 that women were achieved the right to have gynecological services in prison. We'll talk more about other issues as when we talk about women offenders. But ultimately, we do still have some cases coming through the Supreme Court. We really see this as a reflection of society. So some of the current issues that you're hearing is sex changes. Some transgender decisions are currently in the court and being processed. Reproductive health is a reflection of society. We're seeing some of that coming through as well. We're also, as we see more and more facilities getting older. I know in my town in St. Cloud, Minnesota, our prison is well over 100 years old. It was built in the late 1800s. And so they've remodeled it as much as they can, but some of it is just getting very, very old, and we're very limited in what we can do to a building that is solid granite. So as we continue to see a reflection of society and as our society changes, we can expect to have the Supreme Court weigh in on some of those issues and, again, balancing inmate rights with peniological objectives.